Hello, everybody. I hope you all can hear me. I have a little bit of a. Oh, well, there we go. Let's not do that. Um, I have a bit of a my hair is touching me day going on, so I won't be wearing my double glasses. Um, because I also have on headphones to try to make the noise issue. Oh wow, I'm doing a lot of this. Um, also have the sound issue that I want to make sure doesn't cause an issue tonight because I am going to, for my first time, and hopefully I don't fuck it up really, uh, going to be playing a video and doing almost like a react. It's not a video, it's an audio, but you get what I'm trying to spit out. So I'm just gonna like give it a second because number one, I saw Sourdoreen say she had to take the baby outside real quick. Um, and that's the dog. And we love the dog. But also, in addition to everybody else and all of their awesomeness, Sourdoreen is somebody that I value very much because she has a lot of experience that I draw on. And we're going to hang out for a second while we give her time to safely get back to her chair. Not too much, but some. So anyway, I I have the audio. I did have it last night, but and I had this uploaded, but hmm, I wanted to do a reaction because that sounds like more fun. So I also, just so you guys know, um, have not listened to the audio. Now I know what went down. Um, I am very, very excited to hear it happening in real time, or not real time, but hear it happening. And I wanted to react with everybody, I guess. I know others have heard it. Thank you for still watching me as I go through it. But I'm kind of chasing that high from the MOC hearing. I'm not going to lie. And I wanted to have that feeling again where we get to all like listen to it together and scream and laugh and shout and all those things. I won't scream very loud because I don't think that I don't think you guys will appreciate that. So yeah. So here's the thing, right? Trigger warning, you hear Jan a lot. Yeah, that's another reason why I didn't really care to listen to it twice. Truth be told, I listened to bits and pieces of the MLC hearing afterwards, but the first time hearing it in real time was super fun, and some of it I don't want spoiled in my brain. I want to believe that she said, I feel like I don't want to answer these questions anymore. So anyway, I saw a comment I was going to go back to, and now I lost it. So sorry. I really wanted to comment on it. I don't know. Oh, I think it was Amy said somebody said something about their dog recovering. Oh, might have been IB. Recovering right now. And so my dog, we are having thunderstorms and my dog is sedated because her Prozac isn't enough. So she gets some special gel in her gums and she's sedated right now. She will absolutely start snoring during the middle of the stream. She is just behind my shower curtain makeshift screen background. Okay, so we're going to play this audio. I have again not heard it, but I know what it contains. And I know there are points that are going to make me very angry because I was reading through the documents today and I was getting all angry again. As I stated earlier, I was rage reading because you really do forget what kind of bitch she really is. And then you read it, that she gives these timelines and she's threatening to charge her brother criminally. And it's just so gross. So anyway, there are points of correction that I will probably stop or pause and go over real quick. And I just wanted to warn you guys about that. So we're going to, so Goosebump says, rereading some docs, same docs. Yeah, I was reading the same documents that we've already, all the probate stuff. All the stuff's on the Padlet. There is a link in the video description to the Padlet that covers the bankruptcy and probate. I think it's basically a general financial Padlet now for the Owens case. So it's got Ron and Jan's bankruptcy, it's got the estate, it's got some other stuff, financials and all that kind of stuff. And obviously Laura's bankruptcy. So the that stuff is on that Padlet. And like I said, there's a link in the description. Okay, so let me see if I can add this back on. And I kind of don't know how I want to show it. I had it set up like this, but that feels kind of weird because it's like, hold on, we're going to play around for a second. I don't know if there's a better way to do it really. Can I make this bigger? No. Anywho, it's going to be like the black background because it's basically just the audio. So we'll see. If it gets too weird, I'll change it up a bit. Okay, so let me just go ahead and, oh yeah, okay. All the best research says thank you. And yeah, thank you guys. Holy cow. What a team. It's amazing. Okay, let me get back to where I was. And I think, fingers crossed, let's see if it works. Hopefully you guys can hear this. If you can't, please start chiming in real quick, as fast as you can. Even with just oh wow, a Y or an N. Okay.
All right, we are on the record this afternoon. Excuse me. This is case number D202PB 2011-00653. This is in the matter of the probate estate of Elizabeth Williams Naylor. Again, my name.
Okay, I don't want to jinx it, but I'm so excited that you guys can hear. I'm sorry, I had to pause and say that. I don't want to jinx it though, so let's keep going.
My name is Judge Josh Allison. Thank you all for being here today. The first thing we're going to do is have you all who want to tell me who you are for our record, so we have a record of your appearance. There's no one here in the courtroom other than my bailiff and our court monitor. If that changes for any reason, I'll be sure to let you all know. Why don't we start with counsel for the personal representatives, please.
Yes, Your Honor, it's Vaughn Thomas. I am counsel for the personal representative and for the co-trustees of the decedent's trust.
All right, thank you very much, Mr. Thomas. All right, do we have Elizabeth Ann Naylor Owens? Are you here?
Yes, I am, Your Honor.
Okay, thank you. Your screen says Jan Black.
Jan Black is my professional name.
Okay.
Elizabeth Ann Naylor Owens is my legal name.
All right, thank you very much. All right, who else do we have here who needs to enter an appearance? You're welcome to do so now, please.
Your Honor, Theo Offerstig on behalf of Guy Markley Naylor and Dale W. Gunn.
Thank you very much, counsel.
A fun game. Sorry, guys. So real quick, I heard, oh, for people who didn't get the video description, I said Mama NOB, I think is what I called her, Naylor Owens Black. Okay. Anyway, I didn't hear the brother and his husband chime in. I think I'm right about that. I think it's just the attorney that was there for them. So, but so far we have Jan, the opposing attorney, and the judge. So yeah. Okay, sorry. I promise I won't pause that much. I just wanted to check in real quick.
All right. Anyone else who needs to enter an appearance today? Okay, hearing none, thank you. All right, I've got two motions set for our hearing today, which has been vacated and reset a number of times. The motions I have set for hearing are the petition to withdraw as counsel and to substitute counsel, and then also the motion to dismiss. I would propose that we hear the motion to dismiss first, unless folks think that's a bad idea, in which case I'd entertain hearing the motion to substitute first. Doesn't really matter to me, but it just seems to make sense to me to do it that way. Anybody have strong opinions one way or another?
Your Honor, I was under the understanding that this was the motion to reopen probate, that was initially what I had requested of the court, was the motion to reopen it, and the motion to dismiss, I think, was filed after I had requested the motion to reopen it.
Yeah, I'm sure that's true that the motion to dismiss was filed after your motion to reopen was filed. But the November 17, 2025 notice of hearing that was sent to everyone lists two motions. It's the motion to withdraw and the motion to dismiss. Naturally, the motion to reopen will be part of the discussion, but it is not separately set for hearing today. I probably couldn't tell you why without spending a considerable amount of time with the docket. What I can say, if just to cut to the chase, is that if we didn't get a notice of hearing and a proposed notice after the resets and the number of vacatings of the hearings, it wouldn't have been reset. But I'm happy to hear from all of you about why the petition should go forward. That's essentially what the motion to dismiss is arguing anyway. Okay?
Okay.
Thank you.
Your Honor, may I interject? This is Vaughn Thomas. I don't know whether my profile can be seen visually. Not that matters, I presume.
I can see you when you're speaking, and I can hear you.
Very good. I don't need to see myself.
All right.
Your Honor.
In any case, I have no objection to the court hearing the motion to dismiss first, and Mr. Offertig is prepared to do that, I believe, Tio.
Yes, I am. We also have no objection to hearing the motion to dismiss first. If there was an affirmative decision on the motion, it would moot the petition anyways.
All right. Well, let's do this. We'll hear the motion to dismiss, which naturally takes issue with the motion to reopen and the petition. So I've read the motion to dismiss. I've spent some considerable time with this docket, believe it or not, and I've read the motion to reopen and the claims that would be sought to be made in this case. So I think I'm pretty well up to speed. What I'd like to do is to hear from counsel.
Okay, I'm dumb because I tried to click on the microphone on the big icon that it was on my screen instead of the part in the settings. Anywho, so and then, I love that the judge said that they were familiar with the case already, like that they've spent some time on the docket and they're familiar with what's going on. I think that's very important. You see cases that drag out for a while for any given reason, and a lot of things happen, I shouldn't even say a lot of things. A lot of motions and filings happened in the meantime over the course of over a year, I guess now. And you kind of see where they don't connect all the dots in the same way somebody who is specifically following that one case would, right? Because they have a lot going on. So the fact that he said that is pretty cool. And that's one of my comments. Thank you. Bye.
On the motion to dismiss, then we will hear from how would you like me to call you, Ms. Black or Ms. Naylor? What's the best way to address you?
Well, for purposes of this, Elizabeth Naylor Owens is fine. You can call me Elizabeth. I'm named after my mother, whose estate this is all about.
Right. Is Ms. Naylor Owens okay? Is that all right?
That's fine.
Okay, great.
Whatever. Thank you, Judge.
We'll go with that. Okay, thank you.
I appreciate it.
So we'll hear first from counsel who's making the motion, then we'll hear from Ms. Naylor Owens, and then I'll have some questions about what's being pled here along the way, and then we'll go from there. Okay, thank you. Counsel, please go ahead.
Thank you, Your Honor. So to put it simply, today we're asking the court to dismiss Ms. Owens' petition to reopen probate and to also close this probate matter. All of the assets, which was just all the estate assets, which was a Raymond James account, was already transferred to the trust. Any other assets were transferred to the trust prior to the decedent's death. So that would be the decedent's primary residence, a personal property. There was a Bank of America account, but that was set as a transfer on death to Guy Markley Naylor, who I refer to as Mark, and will refer to him as Mark throughout the rest of my argument. So there are no estate assets for this court to probate. And then in Ms. Owens' petition, she doesn't challenge any testamentary instruments. She's not challenging any testamentary instruments, and there are no assets left to probate. If she also requests an accounting from the estate and the trust, all of those issues and the other issues raised in her petition were already fully resolved in the non-judicial settlement agreement. As far as we see it, there are no matters remaining for this court to hear. And with that, I'll yield to any questions from the court.
Thank you very much. I guess my starting question for you, counsel, is you know the estate better than me, obviously. You've spent time with it. I have spent limited time with it comparatively, of course. If put yourself in my shoes for a second, if Ms. Naylor Owens were to succeed, prevail in any of her claims in her petition, would those impact the estate at all?
Well, to answer your question, it's difficult to discern based on the petition what exactly she's requesting. I think the petition misunderstands the difference between a trust estate and a decedent's estate and probate. There's the settlement agreement, and I'd like to just point this out to you if you haven't seen it already. Waives the preparation, audit, and confirmation of further detailed account by any court. And I'm referring to the motion to dismisses
Exhibit A.
Exhibit A. And then it's Exhibit A to Exhibit A, page 7. So according to the settlement agreement, the parties waive the preparation, audit, and confirmation of a further detailed account by any court. They approve the statement of accounting attached as Exhibit A. They approve the administration of the estate and the 2011 trust. Approves the payment of indebtedness and special allocation of cash from the proceeds of the sale of the residence held in the 2011 trust. But I'm not going to go off reading each and every waiver in here. But as far as we are concerned, the settlement agreement was comprehensive and resolved every issue that Ms. Owens is asserting in her petition. They're just, as we say in the introduction of our motion, there are simply no matters contained in the petition for this court to adjudicate.
Okay. All right. Thank you very much. And let me hear your name one more time, your last name, so I can try my best to pronounce it correctly.
Yes, it's Offrich-Tig.
Offrich-Tig. Okay, thank you, Mr. Offrich-Tig. All right, why don't we hear from Ms. Naylor Owens, please? And I may have a few questions as we go along, but I'm happy to hear from you primarily about what you need to happen in the probate estate, which is the basis of the motion to dismiss. So thank you, Ms. Naylor Owens. Happy to hear from you.
All right, thank you so much. Well, obviously, I disagree with the contentions that were just made, and I do have, because it's a bit of a complicated situation, I do have a statement that I'd like to read that could perhaps clarify things a little bit better.
Sure.
Okay. All right. Well, Your Honor, I am asking the court to reopen probate because the estate of my mother, Elizabeth Williams Naylor, was never properly administered, and reopening probate is the legal mechanism designed to address exactly this particular kind of situation. Under New Mexico probate law and the New Mexico Uniform Trust Code, this court has the authority to reopen an estate when required acts were never performed, when assets were not distributed, when fiduciaries failed to account, or beneficiaries were harmed by breaches of fiduciary duty. The facts of this case fall squarely within those grounds. And I want to be clear at the outset here. I'm not contesting my mother's will or trust. I'm simply asking the court to address failures of administration, accounting, and distribution that occurred after her death. On May 24th, 2011, while my mother was gravely ill and lying in a hospital bed in Albuquerque, at the encouragement of my brother, Guy Markley Naylor, and his now husband, Dr. Dale Gunn, my mother executed a new last will and testament and a trust agreement establishing the Elizabeth Williams Naylor Protective Living Trust. This came as somewhat of a shock to me because for many years before that, my mother already had a will.
Okay, back up 1 second, because I do actually want to, I was away, so I didn't get to address this right out the jump. She's absolutely filing this in the wrong venue. Well, she's filing the wrong case in the wrong venue. She doesn't have a probate contention case, or contestation. I don't know how you pronounce it. In my opinion, because I'm not a lawyer, I'm not a financial expert, blah, blah, blah. I'm just spewing words into the internet. But, yeah, this isn't a case for the probate court to consider, because the will literally just turned everything over to the trust. And so the trust takes over now. You have a disagreement with the trust as to how the trust was handled. I don't know that she has standing or anything to argue about that now, but this isn't probate anymore. And then the other thing is, I mean, the nerve, really, right? Like 15 years later, we're going to imply or directly state that we think that Mark took advantage of Mom by setting her up with a will and a trust that, by the way, benefited everybody. Like, it wasn't a sideways or lopsided agreement. So I'm glad I took headache medicine before this started, because I just don't understand why she acts like this. So yeah, here's the thing. Oops, wrong one, sorry. That was before Jan borrowed $25K from her brother and his spouse, right? And actually, I mean, in total it was $60,000. So I think Fletcher Boy knows that because we've talked about this case before. But yeah, I don't know. Bruce says Liz Jan is trying to make the brother look shady as if he was involved in the Diddy case or Gilgo Beach? Giglo Beach? Gilgo? I don't remember how to pronounce it. Gilgo Beach. I always want to say the bad word. Can't say that. So anyway, I'm going to try again not to interrupt very much, but I do have to do something so we're not just staring at a black screen. The whole point is to react. So that's what we're going to do. Okay, let's get back to it. Oh, we have to listen to Jan again. I'm sorry, guys. Hold on.
It was simple, just a couple of pages. She kept it in the desk in her bedroom. She told me exactly where it was and told me that if anything happened to her, that was where I would find it. I understood that document to reflect her longstanding wishes. I was therefore stunned to learn that while she was seriously ill in the hospital, and in fact, I believe that Mr. Naylor and Dr. Gunn believed she was on her deathbed at that point, although she did not die for another 6 months. This new will and trust were prepared by F. Vaughn Thomas, who was the personal attorney for my brother and his now husband. And the will was presented to her at her hospital bed for execution. I was also troubled to learn that although the will and the trust were executed on the same day, they were not consistent. The trust divided the estate equally, 50-50, between my brother and me. The will, however, included a provision giving 5% of the estate to Dr. Gunn, who was not a child of my mother and who would later serve as co-trustee. I was also deeply...
Okay. In my opinion, it is not unheard of for a trustee to be compensated for their efforts. Being a trustee can be a lot of work. I imagine doing anything where you have to talk to Janet for 14 years about coming to get her stuff would be a lot of work. And then on top of that, she's asking you for money because Ron and hashtag dying and all that kind of stuff. So yeah, like, I'm sorry. I can't stand this line of argument because she goes from, matter of fact, here, let's talk about this for a second. She goes from saying she didn't know about this will and trust, she didn't even know about it, to now she's got intimate details. I don't know who gave them to her. If it was a conspiracy to hide it, how does she know everything now? How does she know it was on her sick bed? Secondly, she says, let me see if I can switch this up here. We're just gonna, can I add another screen? No, that's dumb. I don't want to mess it up. She's got in her probate documents, I'll just read it to you. She's got 3 different dates that she says she got a copy of the trust and the will. The first date she says, which is absolutely fucking outrageous and a complete lie, is January 31st, 2023. Sure, right? Anybody believe that? Hands raised? Nah, didn't think so. The second date that she claims, I want to say it's even in the same document, for crying out loud, is January 30th. So we went from the 31st, 2023 to now it's January 30th, 2012. Okay. And she thinks that's a big deal because of some 60-day rule, but she's wrong about that too. Anyway, the 60-day rule exists, don't get me wrong, but she was inside of it. They were inside of the disclosure period. Anyway. And then we have a fourth date. And this one is, ironically, the most consistent error that I see. And it is the same document. January 30th, 2011, before Mom even signed it. So that's incredible. We see that date a lot in the documents. So what the fuck? Idiot. So yeah, please tell us all about the intricate details of how this went down when in a written document you can't even get the fucking date straight. Okay, sorry. I'm gonna stop saying the F word so much because I do want to get monetized. Please subscribe. Okay. Oh, real quick, I'm retiring. I don't know if everybody knows that, but I'm retiring at the end of the month. So yeah, give me money, please. No. I'm fine. Don't. I'm fine. I just do want to do this for a living because it's fun. Okay, I want to like go live in the middle of the day when shit breaks, right? Like that'll be fun. Okay, so I'm going to mute and go back to this ridiculous audio. I might have to take a drink, actually.
Disturbed to learn that the will contained a provision leaving $1 to anyone who contested it. There were only two beneficiaries under the trust, my brother and me. And my brother, as I mentioned, was also personal representative of the estate and co-trustee of the trust. That meant the $1 provision could really only realistically apply to me. That provision was not at all like something my mother would do. It did not reflect her character, and it certainly didn't seem like something she would ever have come up with on her own. The trust itself was explicit and unambiguous. Upon my mother's death on November 21st, 2011, which happened to be Thanksgiving morning, more than 14 years ago, all trust assets were to be distributed outright and free of trust. There were no continuing restrictions, no discretionary delays, no authority to withhold distributions indefinitely. From that moment forward, Mr. Naylor and Dr. Gunn executed exclusive control over all estate and trust assets, and they owed fiduciary duties of loyalty, transparency, prudence, and impartiality to both beneficiaries. I trusted them.
Okay, so let's put a poll here real quick. How many people in chat, like say 1 for yes, 2 for no? How many people here agree that Liz, Jan, Naylor, Owens, Black would execute trustee duties for free? For free. Like no compensation whatsoever. 1, if you agree with that statement. 2, if you don't. Because, right. Yeah, that's what I'm saying, right? Come on. Oops, how do I lost you. There you are. Yeah, we got 2s all over the place. Like, wait. Exactly. Wait, I lost it. Where'd it go? God, it's moving too fast. I say 2 bigger. So I shouldn't ask the questions. It's gonna make me laugh so much. Oh, okay. So, thank you for this. Yes. Ahoy, Helen says, she said they created a living trust and Jan wants to rely on the old will, which is right. A whole separate issue, but and more importantly, isn't a living trust to protect her interests for the remainder of her life at that time. Correctamundo. There's a few times where Jan goes on and on about not being notified immediately that the trust existed. Well, technically, since her mom was the guarantor of the trust, she probably should have been the one to notify Jan that it existed. But hey, I mean, Jan knew about it 10 months before her mom even died. So, and 4 months before it was signed, according to multiple lines in her affidavits and whatnot that are filed. So yeah, she like pretending that 5% is so egregious that, like, I mean, if I just be like, fine, keep your 5%. You already have so much more of my money. Keep your 5%, you little bitch. Okay, sorry. Here we go.
Trusted them to honor my mother. I trusted them to carry out her final wishes. I trusted them to protect my interests. It never occurred to me that they wouldn't, and yet they didn't. Your Honor, the co-trustees submitted a document to this court stating that the contents of my mother's home were somehow appraised on the very day she died, Thanksgiving Day, November 24th, 2011. She died that morning. That filing reflects
No, she's so wrong here. Oh my God. I believe that they correct her on this, but she's so wrong on this. So they have to date it like as of the X date. As of X date, all of the items are appraised at this value, right? Oh my God, what an idiot. Okay, sorry. Wow.
Immediate access to and control over the home and its contents. In fact, over the years, the co-trustees were able to remove and transport many items of my mother's personal property from her home in Albuquerque to their home in Santa Fe. Despite having the ability to move and control these assets, they took no steps whatsoever to send or deliver the personal property I am entitled to my home in Scottsdale. Yet despite that access and control.
Wait. Okay, I know she said this multiple times in writing, but the way she says it verbally is so entitled. Okay. Who's paying for that? Because here's how that works, right? Let's say that they did agree to take the items that she eventually claimed, because it took 12 years for her to actually claim items on a checklist, and not all of them. But anyway, let's say they said, okay, now we're going to ship them to you. Who pays for that? You know who pays for that? That comes out of the trust fund. Like, the same way in her, and I don't know if she says it verbally in her argument. I believe she's probably reading off this one document that I've read a bunch of times. But she wants all these things to happen, a full forensic accounting. She wants, and I've talked about this before, a full appraisal of everything, blah, 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 blah. The trust would pay for that. It would reduce your proceeds, you moron. Okay. Anyhoozle, let's go.
And despite the trust's requirement of prompt distribution, my share of the personal property has never been delivered to me more than 14 years later. No furniture, no artwork, no antiques, no personal effects. Instead, the co-trustees now claim that my share of the personal property is being held in a storage unit where they say it's been for approximately the last 3 years. Through their attorneys, though, they have refused to disclose the location of that storage unit, despite the fact that I had hired an attorney who...
Nope. That's a lie. We have court documentation proving that she was told more than once exactly where that storage unit is, how much it costs, and they wanted her to take ownership of it. So, nope. But go ahead, Jan.
Was working on the case with me for a couple of years and repeatedly requested the location of the storage unit. They have refused to provide a complete inventory of what's in the storage unit, and they refuse to allow me to inspect or retrieve any of the property. I have no idea whether it's in Albuquerque or Santa Fe. I know it's not in Scottsdale.
Curious, Jan, why'd you say Santa Fe? Is it because you know it's in Santa Fe? Is that why? Because out of all the towns in New Mexico, why would you mention the one fucking town that the storage unit is actually located in when you say, I don't know where it's at?
Despite this, they've insisted that I should pay the storage costs for this. The co-trustees, again, had the ability to move and distribute property when it suited them, but chose not to distribute my share. Under New Mexico probate and trust law, fiduciaries may not retain exclusive possession of estate assets for more than a decade while denying a beneficiary inventory, access, and delivery. This is really not a delay. It is a failure to perform a required act of administration. My mother had moved into assisted living approximately 1 year before her death. And from that point forward and continuing after her death in November 2011, the co-trustees allowed her home to remain unoccupied, unrented, and unsold until it was finally sold at my request in the spring of 2023. That was more than 12 years during which the estate's primary asset produced no income for the beneficiaries. That is especially significant because my mother's will expressly authorized the personal representatives to sell or lease the property immediately upon her death. Despite that, the co-trustees did neither. Instead, unbeknownst to me, Mr. Naylor and Dr. Gunn transferred title into their own names very soon after my mother's death, excluding me entirely. I was never informed of this, and I only learned about it years later, in fact, just a few years ago. When I applied for a loan and listed my interest in my mother's home as collateral, I was shocked when the lender told me there was no county record of my ownership interest, only that of Mr. Naylor and Dr. Gunn. During this
Okay. Wrong, 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 wrong. The property was in the name of the trust, okay? I don't know what the trust said. We don't have a copy of the trust. We have maybe excerpts of it, but it's in that non-judicial settlement agreement or whatever. But yeah, so here's the thing. If you're a beneficiary of a trust, you don't get your name in the assets of that trust, right? So I don't know New Mexico law, but I do know that Jan did force her brother to, I shouldn't say force, a deed was signed putting her and her brother in title, okay, to the property and taking it out of the trust. She's super confused because she never would have been listed. So when you put a deed, okay, backing up. When you put a trust in title in most states, they want you to list the trustees. I think it's a stupid rule because the trustees can change throughout the life of a trust, but regardless, it'll say, Big Tiff Dog as trustee of the Big Tiff Dog Family Trust. That's how it'll deed. That doesn't mean that Big Tiff Dog has an individual interest in the property, by the way. So Mark and Dale were not owners of the property, idiot. Second of all, she doesn't have collateral in the house in the way that she just described it. First of all, I think they were probably playing a little game, and that's how she found out. Because we know the mortgage history of them, and I don't have to go into it. But she didn't have that kind of interest. And something about, I read in one of her documents, the lender wanted a copy of the homeowner's insurance to prove that she was on the title, but that wouldn't have even done that. That's not a thing. Okay. Sorry. I just don't like this woman.
This entire period, they did not give me a key to the home. I did not have access. I could not safeguard the property in it, and I had no ability to participate in any discussions affecting it. Probate cannot be considered complete when the estate's primary asset was left idle for more than a decade without oversight or distribution. This non-judicial settlement agreement that was spoken with, let me address that. In 2022, after more than a decade without transparency, accounting, or distribution, I was in urgent financial distress. Dr. Gunn offered me a personal loan, but conditioned that loan on my signing a non-judicial settlement agreement releasing him and Mr. Naylor from further accountability. The loan carried interest and was secured against my inheritance. This occurred in the context of the
Wait. Okay. One of Jan's big arguments is that she did not get the non-judicial settlement agreement until months after it was created. I'm sure that the attorney was drafting it and whatever, doesn't matter. Things take time. You can't just have some internet lawyer slap everything together and call it a day. That's how you end up with 14 felonies. Anyway, so one of her arguments is she didn't get it until 2023. I think it was like some of the dates on it were like October of 22 or November. I don't know. It's when they started putting it all together, and maybe they even negotiated back and forth because she did have an attorney. But she got a copy of it in 2023. The last loan, oh, this is going to bug me. The last loan that she took out from her brother was in 2023. I want to say February. Okay. It was after she signed the agreement. Okay? So, I know I keep saying okay, but so, how was that leveraged against you if it wasn't even created yet? Like, those loans started in 21. So how was a future non-judicial settlement agreement, like, how was your hand forced into signing it when it wasn't even created yet? And you said yourself, and I will find it if I have to, that you didn't get it until, I think, I want to say, just read it today. It was like April of 23. Oh, I know why, because you're a big fat liar. Anyway.
Trust's spendthrift provision, which prohibited me from assigning, pledging, or encumbering my beneficial interest. As a result, I could not independently use my inheritance to obtain financing, while the co-trustees retained exclusive control over the assets and the timing of any distribution. Your Honor, the trust prohibited me from pledging my interest, yet Dr. Gunn, acting as a co-trustee, conditioned a loan on repayment from my undistributed inheritance and used his control over distribution as leverage. In substance, that conduct defeats the purpose of the spendthrift provision and is precisely why court review is necessary. In practice, this meant that the spendthrift provision operated not as a protection, but as a tool of leverage. I was financially constrained, unable to access or use my inheritance, while the co-trustees controlled both the assets and the information. Under those circumstances, the choice presented to me with regard to signing this document was no real choice at all. The agreement lacked full disclosure, pages were missing, inventories were incomplete.
Okay, yeah, I'm going to find it because I know for a fact these dates don't line up with what she's saying right now. I know that for a fact. Okay, anyway, I know that for a fact, number one. Number two, they lent her the money personally. The trust didn't loan her money. Okay, let's be clear. They personally lent her money, and I'm sure it was based on conversations that they had that said, I'm so broke, I'm so poor, run #hospice, right? If you would just let me pay you back out of the money when we sell mom's house. Who can visualize that happening? I can. So that's likely what happened. I don't think she understands what she's arguing right now, but that's basically the title of this. So I'm going to find that document while we listen. Okay. Or documents.
Valuations were unclear. I was asked to release the fiduciaries from any accountability without being provided the basic information necessary to make an informed decision. Under New Mexico law, a non-judicial settlement agreement obtained under such conditions cannot shield the fiduciaries from court review of incomplete administration, undisclosed assets, or breaches of fiduciary duty. At the same time, Mr. Naylor and Dr. Gunn asserted that I owed them reimbursement for costs incurred while they exclusively controlled the property over the course of, as I say, 12 years. They claimed I owed approximately $28,000 in property taxes, approximately $15,000 in homeowners insurance premiums, maintenance and carrying costs presented later as aggregate figures without exact itemizations, and alleged advances by Dr. Gunn, initially stated as approximately $72,000, later increased to $85,000 without full bank records, tax records, or a court-approved accounting. Again, I did not have title, possession, or access during most of the period for which these costs were incurred. I was not provided with the bills as they arose, was not consulted about the expenses, and had no ability to mitigate them. These amounts were treated.
Curious. Did you request them? Like, did you request them? Because if you requested them on a consistent basis and they didn't give you an accounting, you might have an argument there. I don't know about how many years later, but yeah. So yeah, here's the thing that she doesn't get. The trust pays for those things, And then when the trust sells off its assets, you get what's left. They are not personally charging you in full for taxes, insurance, whatever nonsense you just brought up. Okay? Like, it doesn't. And yeah, she's also not a trustee. So there, that's it. Like, okay. Hold on. I'm waving my hand a lot. I caught it in this side of my view. Let's hit play and keep looking.
As personal debts to be deducted from my inheritance before I ever received it, despite the trust requiring distribution outright upon my mother's death and free of trust. The fiduciaries cannot convert estate carrying costs into personal loans secured by a beneficiary's inheritance without notice, consent, documentation, and court review. Your Honor, probate required acts of administration that were never performed. These personal assets were never distributed. Again, I do not dispute the fact that bank accounts and brokerage accounts were distributed. I'm talking solely here about the personal assets. The fiduciary duties were breached, information was withheld from me, and oversight was avoided for years. These are precisely the circumstances in which probate courts reopen estates. So I'm asking the court to reopen probate, to compel a full fiduciary accounting, to require transparency and disclosure, and to allow judicial oversight of this estate that was never properly completed. Again, Your Honor, when we ask for tax records, when we ask what the estate's EIN number was, we have never been given that. We've never been given the tax records. The list of personal property items was bare bones that their so-called appraiser had come up with on the day my mother died. Very limited descriptions, such as a picture of roses or something like that. Nothing to indicate that this was something from the 1700s, and nothing to indicate what its value in truth might have been. It just is ridiculous. And then
well, you're right about one thing, Jan. It is ridiculous. That's not how. Okay. You don't. Okay. First of all, we've seen this document she's talking about, right? This extremely long document that I'm sorry, it's 12 pages long. It's 12 pages long. How is that inadequate? It literally says values as of the date of death. Like, I don't understand what she's going on about here. And it's 12 pages long. Every single item, account, tchotchke that they had is on this list. So it's not like, and there are descriptions that make sense. And there's nothing stopping you from going, okay, Welsh oak cupboard, which one? Were there multiples that you don't really understand? You know, pieces of art, which one? Were there multiples that you didn't understand what they were talking about? Like, this is stuff that you should understand exactly what it is. Okay. Anyway, continuing. Well, I still look for that other document.
A couple of years ago, this same inventory was presented to me again, and at this time, they had made notations about, oh, that my mother had wanted such and such an item to go to my brother, you know, all these different things. Coincidentally, the things that were the most valuable items of antiques and artwork, that, you know, at that point they said, oh, well, she'd wanted them to go to him, when in reality that those things were never delineated on the initial inventory that was presented to the court. So, Your Honor.
Back up. Okay, so those things. Talk about vague. Which things, Jan? Specifically, which items? Because I've not seen one single document that she has prepared or submitted that called out specific items that she did not receive, that she was supposed to receive, or that didn't get put aside for her, that was supposed to be put aside for her. I will not lie. The one document that's the largest is 124 pages, and man, it's a big one. And I did skim a lot of it, no joke. However, if you think you should have gotten something, then how about you ask for it? Okay? All right, we're looking at these loans real quick here. While I am scrolling, I think they're put in this bankruptcy filing backwards and date-wise. Bruce sent me 2 questions, and I'm going to answer them in 2 seconds. Okay, well, first of all, October 11th, 2021 is the first loan. Well before that settlement agreement. Anyway, first question is why can't Jan just go get her stuff from these storage facilities? Great question. We've got 2 storage facilities that we know of that she's had stuff held at, and I don't know if I needed money, like desperately needed money to care for my ailing husband. I would definitely go take those things and sell them, or work with somebody who, I don't know, maybe does that for a living, and have them help me do that so that I don't have to worry about it. It's stuff that I'm, yeah, you should get the things that mean a lot to you, but otherwise it's just stuff. And if there's one thing we saw, they've got enough stuff. So, if you want to swap out some of your personal things, even for things that came from your mom, more power to you. Put them in your home, because now they're just sitting in a storage facility, and it's air cooled or air controlled, temperature controlled, and all that stuff. But still, it's not benefiting you in an emotional sense at all. So regardless, the other question is, so yeah, no, there's nothing stopping her. There are multiple letters from her attorney, from his attorney to her attorney saying, come get your stuff. You want it? Come get it. Here's where it's at. Here's the list of things that we've agreed on. There's still a bunch of question marks there. There's still a bunch of things that neither of them have decided that they want or want to take care of. My feeling is Mark and Dale got everything they wanted, and Jen can have the rest or leave part of it or do whatever, but you've got to go get what you want. Okay? Secondly, yeah, so she is a lazy lasagna. Agreed. So secondly, the question was, why did it take so long for her mom's house to be sold? I wanna go in the Wayback Machine for a minute with everybody and talk about 2011 and 2012. You guys might remember a foreclosure crisis that was happening across the country, where houses were, the value, the market it had plummeted. So it had risen for a long time. And yes, some of that was inflated, but there are other reasons that it collapsed. And so the value had dipped, right? And quite a bit. So my guess is that the value was lower at the time. I also think that, like a common occurrence when a family member passes away, it may have been difficult to sort through everything that they needed to sort through, right? To get, shit, it's 14, 15 years later and Jan still isn't picking up her stuff. So I'm sure it's a lot of work to get the stuff out of the house into a storage facility. And then you've got to decide at that point, because you're the one on the hook for it, how long do I keep the stuff in storage? Imagine the pressure, like my stomach's getting upset thinking about it right now. You've got this whack job sister who has drained you and played on your heartstrings for years and years, decades, your whole life probably. And she's dragging her lazy ass in every single thing you're trying to do to settle this estate, okay? To the point that even her attorney, when they get involved, can't do anything, can't change anything about how it's going down. They can't even help her get to a conclusion, right? So you've got stuff that you've got to figure out, like, what do I do with it? And I do feel like, I don't know them, maybe they're the biggest scammers on the face of the earth. I haven't seen that, but you're related to her. It's possible. I don't care. But I also see how it could happen if you're continually trying to give somebody a chance to do the right thing. And with siblings, it's extra hard, right? Any family, it's hard. It's difficult. So you see that happen, and then time just gets away from you, right? And it's cheaper to pay the homeowner's insurance and the property taxes on the house than to put everything into temperature controlled storage. I can tell you that much. Secondly, I don't know what the trust said. I don't know. Nobody knows, to my knowledge, what the trust said. Did the trust say hold on to the property for 15 years to see if one of the grandkids wants to buy it? I don't know. I don't know. I don't know. Nobody knows. So I'm not going to jump on the bandwagon of they should have sold it sooner, because I don't know what the trust said to do with it. I don't even know if the trust required that they rented it out, because here's the other thing. Okay. When you rent it out, you are renting out, like, then you still have the issue of, number one, being a landlord is a job. Number two, where's all the stuff go? Where does all the stuff go? Then you're fighting with your sister for a different reason. And maybe you're trying not to make things worse on your sister because she's going through a lot. And you're just being a good person, maybe, or trying to do the right thing. And I'm sure communication is an issue in their family. So maybe he should have outright said some things. Maybe he did. I don't know. But like, I can just see, and it was, what, 11 years from the time Mom passed when it finally sold? About maybe 11 and a quarter. So I don't know why, but I don't think it's the big deal that Jan tries to make it out to be. Oh, Bruce, sorry. Bruce says, I'm not saying they should have sold it sooner. I just didn't know if we know why they sold it when they did. I believe they sold it when they did because that's when we really saw the financial crisis creep up on Ron and Jan. They had moved to Scottsdale. They had over leveraged themselves on the Scottsdale house, and I'm sure their credit card debt had been creeping up on them fast. And I don't know, maybe they did pay, well, they clearly paid for something for Ron. I don't think it destroyed them financially, but they paid for some sort of rehab or something for Ron to live in or go to for a while. So that took some things, resources away from them. And I think that's why everything kind of came to a head in March of 23, and that's why the house sold. I'm irritated because Jan makes it to be such a big deal, like they lost out on all this rental income, and they try to say that the rental income data isn't available for the years. That wouldn't make it look good, right? Like, that house isn't earning what they thought it might be earning over time, because again, you still have the expense of putting all the stuff in storage. Okay, I'm sorry, I'm gonna get off my soapbox about it, but wow, I just can't stand the arguments she makes.
The other thing is they are asking this court to award them attorney's fees, and this request is neither equitable nor supported by law. I did not file this petition frivolously. I filed it because probate was never properly completed, assets remain undistributed, required accountings were never provided, and no court has ever reviewed these issues. Courts do not award attorney's fees to fiduciaries for resisting accountability, particularly when their own conduct created the need for this judicial intervention. If they had done what was expected of them, and what I'm sure my mother expected when she died, that the home would be sold immediately or rented, that income would be gotten from that if it was rented, and the income that was missed over the years because they simply let it sit unoccupied was a conservative estimate, $183,000. So, this estate appears settled on paper because probate was closed administratively in February of 2018, but it was never settled in reality. Again, these assets weren't distributed, the information was withheld, and my mother's clear wishes were not honored. So for those reasons, Your Honor, I respectfully ask the court to reopen probate or come up with some other kind of a solution, whether it would be mediation or arbitration, something like that, so that her estate can finally be administered under judicial supervision, so that the personal property, the antiques, the artwork that she and my father had intended for me to have at some point could be distributed to me. And as I say, I have, you know, they refuse to tell me where these things are. And they did say that.
Okay, she just said it like flat out. Like, we're not even hiding the greediness right now. It's the artwork that her mom and dad intended her to have. Her to have. Well, you know what's funny is the will doesn't say not one damn item is because okay, back up. Let's talk about wills again for a second. So if you have a will that says, I want everything to go into my trust, like I've already put my house in my trust and everything else can go in my trust when I die. As Jan's mom did, you can also say, hey, I have actually some personal items that have sentimental value. You don't have to give a reason. This is a list of things that I want to go to these people before we put everything else into the trust. Okay. The list of personal property to be distributed pursuant to Article 3 of my last will and testament, item of personal property, and then recipient line next to it. There is not one damn thing listed. Okay. So again, wrong.
That some of the things are in their own home, that some of the artwork and antiques and things are in their own home. But I certainly have had no access to them. And as I say, they're wanting me to pay storage costs of, I think, $315 or $350 a month, but they refuse to tell me where this storage unit is. I mean, it really stinks.
Okay, thank you very much, Ms. Naylor Owens. I have a couple of questions based upon what Mr. Aufrichtig has stated about the assets in the probate estate. The motion is made primarily stating that, I'm paraphrasing, so don't hold me to this, Mr. Aufrichtig, but it's my understanding of the motion. Basically, it says, look, Judge, there's nothing left in the probate estate. All the assets that were in the probate estate have been transferred to the trust. If Ms. Naylor Owens has any complaints, and she does, we just heard what they are, those complaints are with the trustees of the trust, which may or may not be allowed to be pursued under the laws of the state of New Mexico. We're not going to talk about that in the motion, Mr. Aufrichtig is saying, because that is a separate issue that should not be raised in a probate estate. That's how I understand the motion. And so the starting point for me is to determine, as I asked Mr. Aufrichtig earlier, what is left in the probate estate that needs to be done or undone and unwound. Because as I hear you talking today, Ms. Naylor Owens, it sounds to me like your complaints, your claims, whatever they might be, you talked about fiduciary duties of trustees, that those lie with the trustee, or lie against, against the trustees of the trust. But because all of the assets have been delivered to the trust, there's nothing left for the court to do within the probate estate itself. What am I missing from your perspective in that regard, Ms. Naylor Owens?
Well, I think it's what I'm missing. You know, these were items that they were supposed to distribute to me. There is so much that they were supposed to have done over the years with regard to this estate, from you know, filing taxes, from again getting an EIN.
Right, and let me interrupt you. It's hard to do over Zoom, so I apologize.
Yeah,
but I want to keep this
no
moving.
worries.
But because it seems to me what you're saying is that those actions didn't happen on behalf of the trust by the trustees. And let me use this example. We have a will here. The will says all the assets should be delivered to a trust. It doesn't, the will does not say, for example, deliver some amount of property, whatever it might be. Let's just call it property 1, 2, and 3, just because it's easier. Deliver property 1, 2, and 3 to Ms. Naylor Owens, and deliver the rest of the property, 4 through 100 and whatever, to my trust. If that were the case, then I could have some jurisdiction as the judge in the probate matter to ask the personal representative of the estate, why haven't you fulfilled your obligations under the probate code to deliver property 1, 2, and 3 to Ms. Naylor Owens as provided for in the will? But here, because all of the property goes first to the trust, there's nothing, I don't see that there's anything left for the judge to do in a probate matter because there's nothing left to be done with respect to the assets. All of these assets went to the trust. Now they may be sitting there in a storage unit, not know where it is, being charged $300 and some a month to maintain, but the trustees are doing that now, not the probate estate personal representative. It matters for a couple reasons. First, the probate matters are governed by one set of laws, the probate code primarily. Trust matters are governed by the Uniform Trust Code, among others. And my jurisdiction over particular parties is governed by the rules of civil procedure for the district courts. And in probate matters where we start to have squabbles between and among beneficiaries, those can be brought, but the rules of civil procedure regarding jurisdiction and notice and service all must be adhered to. And I will tell you, I only allow those in very specific circumstances where it appears that the resolution of that action is going to impact the probate estate. One of the beneficiaries, for example, is saying, I want to disinherit another beneficiary. Well, that's going to impact the estate, right? And who gets what. So I allow those as ancillary actions in probate matters when there's something left to be done. But here I don't see that there's anything left to be done. And now I'll cut to the chase. That's not actually true because I've been talking for a while, but it is that it sounds to me like your claims, whatever they are really a standalone civil action against the trustees for breach of fiduciary duty. Those are the words you've used. And that they don't have anything to do with the probate matter. And that's how I see it. But again, I welcome your side of this dispute so I can be fully informed, please.
But it doesn't appear that probate was followed.
What do you want? What didn't get done?
Well, as I say, they should have done, very simple things like, filing taxes, showing where the money went.
This ignorant bitch, like sitting there and spouting off ChatGPT law from her outdated affidavit. I'm convinced she's reading off of her old document now. And talking about how the trustees of a trust should have filed probate documents in an empty probate case makes no sense whatsoever. Like, right. Speaking of documentation, where are all your documents for all your LLCs, Jan? Or are you just a manager or a member? Or are you confused about what that is? Like, yeah. I mean, at this point, ChatGPT can't even help her, right? Like, okay. Make her tea and hold her hand while they showed her the documents. Okay, I for real wish I could figure out how to show two screens here because I guess I'll go over it at the end, but like I'm bringing up every single thing to combat what she says they didn't do. That's all I'm saying. Like, God, this woman.
Showing, none of the things that my understanding is that they should have done and that my brother should have done as the personal representative, these things were not handled correctly. They did not follow
Okay.
what should have been done with first of all, with regard to the house itself, that it was supposed to be, that they transferred title to themselves.
Your Honor, I don't mean to interject, but that's just untrue. That title was transferred to our clients, to my clients themselves. That title was put in the name of the trust for the residents. I just want to clarify that because that's the second.
Their names were what was on there. My name was not on there at all, and I was told this by numerous lenders that
Because you're not a fucking trustee. Because you're not a fucking trustee. Your name isn't on there because you're not a fucking trustee. Okay. Sorry, guys.
applied
Well,
for.
hang on a second. Let me interrupt. I'm not here to have a trial about what happened to the house. I'm not going to do that today. It would be procedurally improper, and it would
Correct.
also be probably outside the scope of the pleadings as they exist right now. So I'm not going to, I don't need to know what happened to the house. What I need to know is why you want to reopen the probate estate, because you think that someone needs to file taxes. Okay, I heard you on that. What else do the personal representatives of the probate estate need to do that you believe was not done?
They did nothing with regard to an accounting of, nothing was followed. They allowed the place to sit unoccupied for years, and I had absolutely no ability to challenge this.
But what are you going to challenge? That's my question. You've told me you're not going to challenge the will. You've told me that you're not going to challenge the trust. So if the will says, hang on a second, if the will says all of the property goes to the trust, what are you challenging in the probate matter? How are you stepping in to challenge what? There's property that hasn't been transferred to the trust that you believe needs to be?
There's property that hasn't been transferred to me that needs to be.
From the trust?
Yes.
Okay, that's a trust dispute, right? Not a will dispute.
So, just so that I can be clear, is it your view that they handled probate exactly the way it needed to be handled?
No, I don't make those determinations. I ask you what you say needed to be done. So far, you have told me they needed to file taxes.
They needed to have an EIN number. They needed to administer the estate properly, and not to take assets for their own personal use.
So you have a claim that somebody, as a personal representative, transferred assets to somebody that shouldn't have gotten it? Is that what your claim is?
Well, I'm saying I don't know where those assets are. I'm saying the personal representative, who was my brother, refuses to tell me where those assets are, and yet wants me to pay storage costs for those when I have no idea where they are. I don't want them in storage. I should have been given them when my mother died.
Okay. So you want taxes, you want an EIN, you've said, you want an accounting of what was distributed from the estate. What else?
They also, there are some unusual things that happened with regard to the home being ransacked at one point when I finally had said to my brother and Dr. Gunn, hey, I really could use the proceeds from this. And at that point, then I was told that the home had been ransacked, and they sent me pictures of things just looked like animals had gone through everything in my mother's bedroom and thrown things all around. And it was an incredibly upsetting scene to see everything on the floor. It was so that it looked as though you couldn't even walk in the place. And they told me that the place had been ransacked. And yet I've had body cam video from the police who went to investigate this alleged ransacking. And you see where there are works of art, valuable works of art from the 1700s and 1800s that my parents had. In this same scene where items are.
I thought the inventory didn't determine what valuable artworks there were and what period they were from. You just said that not too long ago. Just saying.
Strewn all around the floor. You see in the living room of the home, there are artwork boxes, cardboard boxes, and packing materials under the works of art to be packed up and taken out of the home. So it is strange that the place was ransacked, and yet the folks who did that brought boxes to cart the artwork away and pack it up nicely.
Okay,
I don't know what happened. I wasn't told about this in any kind of a timely manner at all. And so, like I say, there are some things that I would like answered. I'd also like to know, I was told when I asked about, well, if there were things taken, if there was artwork taken, can we, file for an insurance claim? And I was told, no, that for whatever the reason, they didn't want to file for an insurance claim. And yet they've wanted me to pay for the cost of insuring the place over the years. And yet when there was a theft, they are not interested in filing an insurance claim. I mean,
yeah, because if you know how insurance works, if you've ever actually had anything worth insuring that you didn't buy from the desert, your deductible might not be worth a claim. Like, depending on, I don't know. I didn't look. I'm sure Jan has her tallies all up in there, but I don't know what was lost in the ransacking. But I don't know if it was worth an insurance claim either. So I don't know how many people know this. And please, I mean, I'm a little bit of an expert about insurance, but every state varies. But there's this general rule that if you have 3 claims on your homeowner's insurance in a 3-year period, they can cancel you on the 3rd claim. So really, you only get 2 chances to have a claim. And so you don't really want to waste your claims if you can avoid it. And I just can see why. I guess I can see why. Like, we've had some things, like we had a water issue that was totally legitimately a claimable item. We just chose not to because it wasn't worth the small amount of the claim to put a claim on our record, right? Like, and there is documentation in there that they never took mom's name off the insurance, or I shouldn't say documentation. There is a claim that they never took mom's name off the insurance, and they probably did that to save money on the homeowner's insurance over time. And maybe it wasn't the greatest idea in the world, but I can see for that reason too why they didn't want to file a claim. I don't think it's a huge fucking conspiracy, okay, Jan? That's all.
There are just some very strange things. And as I say, Your Honor, I had completely trusted my brother and completely trusted Dr. Gunn for all of these years until it really became very suspicious to me that they wanted me to waive an accounting of these things. And the more I thought about it, the more I thought this just.
Wait. I know she keeps going on and on about this waiving the accounting, waiving the this, waiving the that. She actually, according to the documents filed by the attorney and the communications between the 2 attorneys in the history of this file, there were things that were provided to her. She did receive accountings and inventories and all those kinds of things. She received the EIN that she keeps claiming she didn't receive. She got that information, okay? So it's not like this big cloak and dagger thing that they're hiding everything from her and she waived it in the settlement. Basically, they said, this thing has gone on forever. We've tried to work it out. Here's where we can kind of like start fresh and go, okay, you take this, I take that, and we call it a day. And we're not going to go backwards and file things that we don't want to spend money out of the trust, because again, when you do these things, you have to spend trust money. Trust money pays for everything that has to be done according to the trust. Okay? It doesn't come out of the individual trustees' funds. That's not how it works. So rather than soak up all the money, recreating or redistributing or doing whatever with documentation over time, the items are still there. You just got to come get them, and then we can call it a day. Like, we don't have to rehash everything over and over and over again. And I'm sure she made it painful. Anyway.
Things are not right in this.
Okay. Why, Ms. Naylor Owens, is this Exhibit A, Statement of Final Accounting, that is attached to this non-judicial settlement agreement? Why is that not enough to satisfy the accounting provisions of the probate code for you?
I don't have that with me right now. Is that the inventory that they had?
It says Exhibit A, Statement of Final Accounting, and it's 12 pages long. It goes through the inventory. It says value of
Correct.
estate on death, and it's got a bunch of rooms, front hall, den, kitchen, master bedroom, etc., and it arrives at a final value for
Correct.
the amount. Why is that not a sufficient accounting for you of the probate estate?
Well, because if you look at that, it is, again, a very bare bones list of things. These were valuable pieces of art and antique furniture. And when you look at what they presented there, it would be like saying a picture of a woman with a faint smile and describing that as the Mona Lisa. I mean, you can't put any context to it. And they said that they have photographs of these items. Under my understanding, they were supposed to have photographs of these things and photographs, therefore, of things that were stolen. And yet they have produced no photographs of these, so that in order to get an actual fair accounting of what was in the estate, you really need to have more of a detailed appraisal than that. I mean,
first of all, ding dong, it's an inventory, not an appraisal. Okay, first of all. Second of all, it's 12 fucking pages long. It's pretty detailed. And I'm seeing things on here like Lucy Horton Green portrait, Dr. Joel Green portrait, Stephen Gore Brown portrait, Hannah Brown portrait. Like, these are, I'm assuming, artists or portraits of people. Like, and I'm positive they didn't own the Mona Lisa. We have a grandfather clock circa 1800. Like, blue and white, 19th century lamp. Maple bracket base, 19th century chest. These are detailed items on this list. And again, it's an inventory, not an appraisal.
That really is not very helpful. And they told the police that they had photographs of these things, and yet they, I'd like to have the photographs so that we can submit those to a real appraiser and really get a market value on them.
A real appraiser. Again, do you know who pays for that, you fucking idiot?
Those things. I do have a video that my father did with me in, I believe it was 1988. And my father and I were walking through the home, and he was explaining to me on a lot of the items what they were, because he wanted that done for estate purposes. He had explained what the items were and where they were, the years that they were from, and that kind of thing.
Let me interrupt you again just to keep things moving. I apologize. I'm looking at this non-judicial settlement agreement effective April 15, 2022. It's Exhibit A to the motion to dismiss probate. On page 5, and this is specifically referring to that statement of final accounting that I was just referring to, it says each of the undersigned hereby acknowledges that he, she, or it has reviewed the attached exhibits. That statement of final accounting is one of those exhibits. Agrees that the exhibits show an accounting of all transactions involving the assets of the estate and of the 2011 trust. That said exhibits are accepted as a complete and full summary accounting of all transactions within the estate and the 2011 trust. Each party approves of said accounting and distribution. And you signed this agreement, isn't that right?
Correct. And as I stated earlier, I was under a certain amount of duress to sign that. And as
Liar.
when I signed that, I was fully trusting that my brother and Dr. Gunn would distribute the assets that they hadn't distributed up until that point. I trusted that they would. And they didn't. They still haven't. And you know, as I say, I hired an attorney for $5,000, and the attorney went back and forth with their attorneys over the years, and they will not tell me where these things are. And you know, as I say, then they came up with a list, you know, a couple of years ago, where they were delineating who, you know, oh, my mother had said that this should go to my brother and all this kind of stuff. And it's odd that that wasn't at all included in anything that they'd presented to the court or that my mother had spelled out in her will years earlier. She trusted my brother to split everything fairly. That's all I'm asking is.
Okay, no. So what happens when you have a will that has the list of items that Jen is trying to say exists, and then you create a new will, it supersedes your old will. Otherwise, you just file, I think it's called a codicil in some areas, but basically it's like an addendum to your will. So the fact that there's a will from May 24th, 2011, May whatever, 2011, that's the will. That's the will that doesn't have any items listed separately. So, like, again, you still haven't gone and gotten the things that you say you are supposed to have. So, anywho, let's get through this.
For a fair distribution. And it hasn't happened up until this time. It needs to happen. And as I say, you know, we had even proposed mediation or arbitration, something like that, and we were stonewalled. So I come to the court to try to get some sort of reconciliation on this.
Okay. All right. Thank you very much. My last question. So you've told me that you want the probate estate to file taxes. You don't believe that has happened. I'll talk to Mr. Offertig here in a second about that. You said you wanted an accounting that was more detailed than what was provided in the non-judicial settlement agreement. Was there anything else you wanted the probate estate to do? I know you talked about distribution. I believe that is now a trust issue, but you've mentioned those things. Is there anything else that you're asking that for the probate personal representative to do?
Well, I'd like an accurate appraisal, and I do not feel under any circumstances that I should be held accountable for costs that were incurred because the personal representative did not do his job in distributing these things more than 14 years ago. I shouldn't be paying for storage costs on you know, when I don't even know where the stuff is. I shouldn't have paid for insurance, although it seems they had the insurance listed under the name Elizabeth Naylor, which would be my name, which was also my mother's name, and it was insured for years, I believe, under the name of Elizabeth Naylor. So if it was insured under my name, that was improper because it was improper because my name wasn't on the title. And if it was insured under my mother's name, she'd passed away. So that doesn't make a whole lot of sense to me. And then when
No, she didn't, actually. So Jan received her full half share of the house when it sold. So no, anything that they paid over time was not reimbursed back to them. The insurance, the taxes, nothing. And I just did the math on the one inventory that discloses it, and the claims, if those items really are worth the value they said they were, the insurance claim would have been $8,600. So about, I'm assuming the deductible was $5,000, $3,600 in a claim, which is just fucking stupid, Jan. But okay, you do you, girl.
theft occurred, they're telling me, oh, we can't file an insurance claim. And I think they had said that I think they said that the insurance deductible, they didn't want to file an insurance claim because the insurance deductible wouldn't be met. And yet I believe they claimed that there were 5 or 6 paintings, again, from the 1700s and the 1800s that were stolen, and that wouldn't meet the deductible of $500 or whatever it would have been.
Okay. All right. Well, thank you very much, Ms. Naylor Owens. Appreciate your presentation today. Thank you. Let's turn back to Mr. Offertig on those issues concerning EIN for the estate, filing taxes, those other administrative issues. Happy to hear from you on whether those have been done or have not been done, and what's going on there. Please. Thank you.
Thank you, Your Honor. And I might defer a little bit to Mr. Thomas on this background, just because I was about 15 years old in 2011. Don't really know what was going on. But
Mr. Thomas, I just want to know if the estate has filed its final tax return. That's really what I need to know.
May I speak to that, Your Honor?
Please, Mr. Thomas.
Frankly, yes. However, there was no tax due either from an income point of view because of expenses and deductions that they had. And the personal representative and the co-trustees were advised as much by a CPA. Secondly, the appraisal that is reflected not only in the inventory filed with the court, with the footnote that all of this was provided for information only in as much as the assets were in the trust, and the appraisal, same numbers appear in the trust, were the result of an appraisal. I think that it's a classic exaggeration, malicious, on the part of Mrs. Owens to suggest that was all done on the day that her mother died. She overlooks the simple fact that for tax purposes, step up in basis and estate tax returns, if one is necessary, all of those assets have to be appraised as of date of death. So in answer to your question, yes, the estate and trust have an EIN, filed the tax returns as required by law, and the accountings are complete with appraised values as of the decedent's date of death, not the date of the appraisal.
Okay. Thank you very much, Mr. Thomas. Thank you, Mr. Offertig. And I'm looking at the September 20, 2012 inventory and appraisal. It appears to be the same, or primarily the same, if not identical to the one that is attached as Exhibit A to the substantially the same, the one that's attached as Exhibit A to the non-judicial settlement.
Yes, that's correct, Your Honor.
Okay. All right. Thank you very much. Then I don't really have any further questions. Let me tell you how I see this. I see my job here as the judge presiding over the probate matter as one that is fairly limited in scope. My job is to determine whether there are disputes as to whether the personal representative of the probate estate, not the trustees of the trust, but the personal representatives of the probate estate have fulfilled their obligations under the probate code in an informal probate proceeding that did not have a supervised administration. Ms. Naylor Owens today has raised issues concerning the filing of the taxes and getting an employee identification number along with an accounting and some appraisal and distributions. Let me go through those one at a time. With respect to the accounting, that's probably the one that is the most significant, at least from my perspective as the judge presiding over the probate matter. The accounting that is provided both on September 20th of 2012 with the inventory, and then that's really the inventory, and then the accounting that is listed in the exhibits A, B, and C. I think there's a C that show how the assets of the estate will be distributed. Maybe it's just A and B, exhibits A and B of that non-judicial settlement agreement. Those are sufficient to satisfy the requirements of the probate code, meaning with respect to the personal representative's obligation to provide an inventory and an accounting of distributions. And I believe the evidence shows at this point that Ms. Naylor was made aware of those, both back in 2012, but then again upon the signing of this non-judicial settlement agreement. And I say specifically was made aware of because Ms. Naylor Owens has raised an issue concerning whether she is bound by that settlement agreement or not in light of her claimed issues of distress. And I'm not making any findings of fact or conclusions of law with respect to that issue because it does not affect the probate estate. And so I'm simply concluding that the inventory and the accounting that are attached to the non-judicial settlement agreement are sufficient to satisfy the personal representative's obligation under the probate code in that regard, or in those regards, I should say. So that's number one. Number two, with respect to the tax return and the EIN, I'm going to accept Mr. Thomas's representation as an officer of the court today that those taxes have been filed on behalf of the estate. If the estate when was the estate closed, Mr. Thomas? Let's start there. The estate, not the trust.
Technically, the estate was closed by Judge Bacon, now Justice Bacon, administratively on or
2018?
about February 2 of 2018.
Yeah, exactly 8 years ago today. Isn't that ironic?
That's right.
Okay, so issues concerning taxes and performance of those obligations as personal representative, frankly, the time has expired for those. Those issues are gone. With respect to the administration of the estate, this court does not need to get involved in those issues concerning the sufficiency of final tax documents, given Mr. Thomas's representation here and the fact that the estate was closed 8 years ago. I'm not going to reopen the probate estate to comb through tax returns to see whether they were sufficient or not on behalf of the probate estate. So I'm going to overrule that objection raised by Ms. Naylor Owens today. And you can't file taxes without some sort of tax identification number, so I'm going to overrule that objection as well. What that leaves us with then is Ms. Naylor Owens' complaints against the trustees of the trust. Her fiduciary duty claims, I'll call them that. We've heard a lot about those allegations today. Of course, this court is not making any factual findings about the truth or falsity of those allegations. I just needed to hear what Ms. Naylor Owens' claims would be so that I can determine whether we should reopen this probate estate or not. And I'm concluding that there is no reason at all to reopen the probate estate. So what I'm going to do is I'm going to grant the motion to dismiss because it's dismissing this ancillary action that Ms. Naylor Owens wants to file. But because I'm not making any findings or conclusions with respect to the legal sufficiency of that petition, I'm dismissing the petition and again closing this estate without prejudice to Ms. Naylor Owens raising those claims in another lawsuit should she choose to do so. And those claims being, to be very clear, hang on one second. The claims that are raised in Ms. Naylor Owens' March 24, 2025 petition to reopen probate, compel distribution of estate assets, and order final accounting. The only issue there that's germane to the probate estate as opposed to the trust is the final accounting, and I've concluded here that that issue has been addressed satisfactorily under the probate code. So the motion to dismiss will be granted. This probate matter is closed. Ms. Naylor Owens, whatever rights you may or may not have had to pursue the claims that you've made in your petition on March 24, 2025 are not being adjudicated by this court in any respect. So that is what the dismissal without prejudice means. It means you'll have to undertake to file a separate legal action should you choose to do so in accordance with the laws of the state of New Mexico or whatever laws govern the trust and the rules of civil procedure for the district courts. Okay, having said that, I'm going to ask if there's any questions I can answer or do my best to. We'll start with Mr. Offertig and then we'll turn to Ms. Naylor Owens. Please, Mr. Offertig, any questions?
Your Honor, I was just wondering if your ruling did include a determination about the respondent's request for attorney's fees.
I'm not going to grant attorney's fees to anybody. For one primary reason, you're going to argue, if you continue these disputes, you will be arguing a lot about who should pay for what. You can simply roll this over into those arguments because all of this had to do with the trust. I mean, I think, yeah, I'm just going to stop there. I just don't think it's worth it. Okay, thank you, Mr. Offertig. What else?
Nothing else. Thank you, Your Honor. Would you like me to prepare the proposed order?
I will take care of it that way. You all don't have to worry about it. I'll do it this afternoon. I'll get the order entered. If anybody disagrees with the order or believes that it leaves matters that need to be adjudicated, you're certainly welcome under Rule 58, I believe it is, and Local Rule 2. What is the rule? I don't remember the local rule, but there's a local rule as well that you can submit to me a proposed order if you'd like, okay?
Your Honor, a quick question of procedure. There is before you that separate petition to for court approval for the withdrawal of me as counsel and the substitution in my place of the Summer Law Firm. I take it with the dismissal based on your order that that's rendered moot, but for clarity, it would be appreciated if the order simply stated words to that effect.
Okay. I think that's fair. I believe that is correct. The substitution motion is moot. If it weren't, I would grant.
I don't know how much more is actually, because again, I didn't listen to it, so but I will let it play out. But so Bruce says best guess on where the money went: 1, gambling; 2, spending on shit; 3, LLC losses; 4, paying lawyers; 5, horse hobbies. I say all the above. I think we have a little bit of evidence to show it's all of the above. So you put everything together and that's financial distress.
I regularly grant those when folks need to change counsel. So I don't see any reason that wouldn't be granted. But for our purposes, procedurally, it simply denied as moot because this case is closed and the representation of folks, at least within the context of this probate matter, as it exists in this court, you all can handle with your respective clients.
It's over. Okay.
Okay.
Thank you, Your Honor.
Thank you. Ms. Naylor Owens, please, any questions that I can do my best to try to answer?
Yes, given the fact that Mr. Thomas says that there were tax returns filed, would it be possible for me to get copies of those since I was not given them over the last 14 years?
I'm not sure I can answer that question. You're going to have to first raise that with Mr. Offertig.
What part of the trust is not under the jurisdiction of this court do you not fucking get?
And then with Mr. Thomas.
Because I should have been entitled to those, correct?
Well, you don't get to cross-examine me, Ms. Naylor-Owen, unfortunately. But
No, no, Your Honor, I'm asking as a, you know, I'm asking because it was my understanding that I was entitled to those things.
Get it out, Jan. I'm asking.
Depends.
Copies of the taxes.
I'll just leave it like this. It depends on who is entitled to information under the probate estate. And I'm going to leave that to Mr. Aufrichtig and Mr. Thomas to determine. I think it would make sense that you would get those tax returns, but it may not be a legal right that you have. And I don't know the answer to that question. As it sits here today, it's not properly before me with respect to the parties. So I'm going to ask you all to confer on that. I don't know to what end. I mean, the estate's been closed. If it has anything to do with the trust, I suppose you can ask as a beneficiary of the trustee, but I don't even know that. So I don't know is the short answer, Ms. Naylor-Owens. So I can't answer that one. I apologize. But if you have any others, I can at least entertain them and let you know if I can.
With regard to, again, photos of the things that they said to the court that they filed the inventory list, but they have failed to include with the inventory list photos of what was included in the inventory. And there's no way you can order them to do that, even though they claim that they had them.
Yeah, I'm not going to order them to file photos of the inventory because it's all been distributed to the trust. So if the trust has assets, you can certainly, as my understanding as the beneficiary of the trust, you can ask Mr.
I have a feeling he's about to pull out a flowchart drawing. Like, here's a trust. You're outside of it. Oh.
Aufrichtig what you are as counsel for the trustees as to what you can and cannot get if it exists. So I'm not going to order them to deliver any photos, no.
Okay, will your order also include the fact that you're not ordering attorney's fees?
Sure, yeah, I can include that, yeah. I will include that. Happy to. What else?
What about with regard to the other items that they are wanting me to pay with regard to insurance and things like that over the years, taxes and, you know.
Yeah.
I don't believe it. I don't believe it. I don't believe that she's this fucking stupid. I don't believe it. I don't believe it. I think she thinks, because manipulators do this, that if she just keeps talking long enough, she'll win something, some little argument, so that she can say, see, look, they had to do this. Exactly like we've seen in every fucking filing that Laura has filed. See, because Clayton knew about that investor, it's not a big deal. I'm innocent. Like
that.
I see those as disputes between a beneficiary of a trust and the trust and or trustees. So I'm not going to weigh in on those. Those are all parts of your claims that you may continue to pursue under the laws and our procedures if should you choose to do so. But I'm not going to weigh in on those today.
Okay. And where would be the proper place to take those?
I cannot give you any legal advice. I'm sorry.
Okay.
So I'm just going to have to refer you to an attorney and or any number of legal clinics through our State Bar of New Mexico, through the University of New Mexico School of Law. But no,
okay, and there's nothing that you can do to compel them to tell me where the personal property is, where the storage unit is.
No, I'm not going to do that because those disputes.
Hey, Jan, give me a call. I know exactly where the fuck it is because it's in the court filings.
because that would require me, first of all, to have an evidentiary hearing about who said what, when, and where. And I'm not going to do that, number one, today. Number two, because that dispute is really between the trustees and the beneficiary of the trust. Once the
Okay.
property goes over to the trust, a different set of laws apply. So I'm not
Okay.
going to weigh into that today, that's for sure.
Okay.
Peter.
Anything else?
Not for me. No,
Okay.
thank
All right, well, I will
Thank you, Your Honor.
Thank you all very much. I appreciate your time today. I will get this order entered. And again, if any of you believes I've left anything out, you certainly can file. It's probably easiest just to file a request for a presentment hearing along with the proposed order you would like to have entered if you don't think I've reached the issues that need to be reached. Okay. Thank you all very much. I wish you a very pleasant rest of your day. We will be in
Hello. Okay, so let's just go over a couple of things here. Just a couple of things. Hold on here. Let me stop and add. Wow. Yeah, I am glad I listened to that with everybody together, because yikes on bikes. Like, wow. Okay. So here's the will filed with the court on December 16th, 2011. And here's the page of personal property items that you would list normally in a will that you wanted singled out before you transferred all the personal property to the trust. I will also say that the document and files indicate that they spent a good amount of time getting everything appraised. I think they finally got everything finished up in June of 2016, maybe, or excuse me, September of 2012. We did a final appraisal. Let me add that screen on here. Stop. Yeah, sorry guys, I'm still not super great at this part, but I'm working on it. Oh, no, I don't want to do that. Is this the one? I hope it is. Yeah. So, I don't want to show that account number, even though I'm sure it's gone. But this is our final accounting. It was filed with the court in 2012, I think September. And look, we've got things, pretty well delineated here and described. Young girl with King Charles Spaniel portrait, $2,500, again, with the portraits. I'm not trying to be mean, but some of this art seems oof. So grandfather clock circa 1800. Again, I told you all these things are right. These items I was never given. Well, let's just look here at El Batamo. All parties entitled to notice. Well, boom. Here we are. Right? You got these things. You received this information. Stop pretending like you didn't get anything. That's not even how it works. Okay. Anyway, going back to, she didn't even sign the agreement, the settlement agreement, the non-judicial settlement agreement, until June 22nd of 2022. So that was after she had already taken out 3 loans from her brother. How were you pressured by the settlement agreement to sign the notes? Are you saying you were pressured to sign the settlement agreement because of the note? It doesn't make sense. It's a loop, right, that you can't get out of. I don't. Okay. Yeah, and that's the thing. It was 12 pages. It was very clear and detailed, and that wasn't even the appraisal. That was just the inventory, with a list of what everything said it was worth. So I just don't get you, woman. I don't get you at all. I had other points I wanted to raise, and I can't even because I'm so irritated by them. Oh, yeah, let's talk about this one. Okay, let's talk about this one. So her little 5%, 5%, okay? The 5% that she is so very concerned about. She says in this filing, oh gosh, that's awful. Let's see if I can make it bigger. Okay. First of all, this is hilarious to me. So she's somehow perplexed by the fact that from September 20th of 2012 until 2023, the value of the estate property went up. Like, well, oh, okay, back up a second. If nobody was living in the house, the insurance claim could have been a problem too. Right. Like, there's no reason to open that can of spiders for whatever little bit of money you might get out of it. I understand that every single penny that you can clutch with your crispy hands is important, but come on. Like, let's use some intelligence. Okay. Yes, she did buy the house. They did buy the house in Arizona furnished. She has a whole storage unit in California of everything that was in that 4-story house in San Francisco. But, you know, we're not talking about that. Anywho, the amount, the difference that she's talking about that they would have received, 5% or $20,000, whichever is greater, the amount they gave in the settlement agreement would leave them with $28,000. So they got an extra $8,000. $8,000 when they spent like $90,000 plus some taking care of the property and storing her shit. Yeah. Okay, Jan. Whatever. These are our dates here. January 30th, 2012. Then we go to January 31st, 2023. These are all dates that she supposedly didn't get the trust until this date. It like the flex, it varies depending on the argument she's making. Here, she got it January 30th, 2011. That's wild. The trust didn't even exist at that point. Does the bankruptcy court, Liz is asking, does the bankruptcy court know about that storage unit? Sounds like someone needs to have a yard sale to pay some creditors. Well, which bankruptcy? So we have to be clear in this family which bankruptcy we're talking about. Because so Ron and Jan's bankruptcy was dismissed. I don't know if anything's going to come out of it investigation-wise, but it was dismissed. So at this point, it's fair game to be sold off. Anything in there, it was Ron and Jan's account, supposedly. I don't see anybody else's name in the claim that was filed. So Laura's, what I'm trying to spit out, it's been a long night. What I'm trying to spit out is that Laura's bankruptcy wouldn't be affected by the storage unit. Even, I mean, if she has some stuff in it, maybe, but the actual unit itself and the account that surrounds it doesn't affect Laura's bankruptcy that much. Like I said, other than if she has stuff in it. Or they can donate it to a women's shelter. Well, I know that, you know, when Laura, because she's such a proponent of advocacy of that, she filed in her lawsuit to Greg that she wanted the court to know that she would donate anything she won to a charity, a women's shelter, whatever. Nonsense. And didn't even pick one, didn't say, like, it was just such, it was like, ugh. Anyway, so she must have a list of ones that she would prefer that stuff get donated to. That's a freaking great idea. Why don't we do that? Like, yeah. I mean, if there's property that Laura has that's excluded from her bankruptcy filings. 100% it's a problem. We'll see if she fixes her filings to whatever, adjust for that. Okay, I thought I had the January 11th date saved on a couple of pages, but apparently not. Okay, so oh no, remove. So yeah, I guys, I don't know. Hold on a second. Real quick, because we gotta have the husband's on his way home. Okay. So the math ain't mathing. Ain't that the truth? I think that, again, I don't know. I don't know him. But I feel like the brother is probably just a passive person. And I mean, that is not an uncommon dynamic when you have somebody like Jan in a family, right? Like you have a Laura, you have a Jan. You have somebody who sucks all the energy out of the room, and other people just keep the peace as much as possible. I thought I suck. Have the creditors filed for judgments? I mean, we haven't seen any lawsuits. No, we haven't seen any new lawsuits come out yet. It sometimes takes a beat, and the thing is, they've all been given copies of the filings. They don't know what we know, right? They might not consider it worth pursuing. The creditors. Sorry, I should have read the question out loud. I don't think I did. So the question from Fletcher Boy was, have any creditors filed for judgments against Ron and Jan yet? And because their bankruptcy was dismissed. And no, they have not. The question is, somebody's answering a question that says, yes, it was listed on their bankruptcy filing as a monthly cost and a big cost too. If you're talking about the San Francisco storage, it was $750 a month is what the expense was, and it had not been paid for a very long time. And I'm sure that's because Jen has become a master at please pour me, hashtag hospice, hashtag he's on his last leg, right? Like it's Bruce Clayton knew the paintings for Mona Lisa. Bingo. Right there. Right there. Clayton knew. So that's how it, you know. I just oh, you know what I did have? I was gonna go over real quick since we were on this. Sorry, where'd it go? I had it pulled up. I was gonna pull up the final. Go back to, actually, let's do it this way. I was gonna pull up the final order that the here we go. Let's pull this up real quick. And this just we'll finish it up with this. That's the wrong one. It's been a long day, guys. I was rage reading most of the day. I just can't get over how irritated I get when I read that stuff that she says. Real quick before we start that question. So when will the house be foreclosed on? I don't know. They're probably trying to mitigate it right now and do a modification. I don't know if it'll get approved, but they'll most likely at least try to do at least one. And then the filing from Chase Bank. The question is, whatever happened to that filing from Chase Bank? Didn't they sue Jan or Ron or something? Yeah, but they dismissed the case because they can bring it again later, but they dismissed the case because of the bankruptcy. They have to, actually. So that's what happened there. Okay. So this is just basically the the final order granting the motion to dismiss the probate. So this is the order that we saw the judge talk about, that would be, he probably had the attorney prepare it and he just signed it, stating that the hearing happened and the court heard arguments from both sides basically, and the court is stating that it has jurisdiction over the probate case. We heard that. Can you make them? Okay, I'm gonna not make jokes. That Jan doesn't contest the last will and testament, other than she did vaguely accuse her brother of fraud. She doesn't contest the trust, and the probate matter was closed administratively in February of 2018. That just means nothing happened on it because everything got transferred in the trust, so the estate was basically closed for administrative reasons. Like, nobody filed for it to be closed, it just closed for non-activity. And that all the assets of the probate estate have been transferred to the trust in accordance with the will. Explains that a statement of final accounting was provided and accepted by the court. The final tax return for the probate case has been filed, and the time to challenge the sufficiency of that return in this probate matter has expired. There are no further matters to be adjudicated as part of the administration of this probate estate. The remainder of Ms. Naylor Owens' complaints raised in her petition to reopen are made against the trust and the trustees of the trust. As such, they are not properly before this court in the probate matter. No party is entitled to attorney's fees. They're allowing the withdrawal of counsel because I'm sure that guy is long retired. And that Markendale's motion to dismiss the probate being reopened is granted, that everything that Jan asked for is denied in big bold letters, and the probate matter is therefore closed. So that's it. That's all she wrote. Like I said, no parties awarded fees, blah, blah, blah. That's all she wrote. We'll see what Jan does with this. I don't know. Gives me a headache thinking about it. We'll see what she does. Maybe something, maybe not. You would think that they would maybe focus on what the fuck is going on in their house right now and let this stuff go. But I'm guessing that they think that if they can win one more case or one more hearing or one more argument, that'll solve all their problems. Yeah, so there's really no reason to dismiss with prejudice. I mean, I think it's like the first time they give you a without, and if she brings more frivolous claims, then the attorney can claim, request for it to be with. But it's pretty common to do the without. I don't like it either, but I think it's pretty common. Yeah. Did you really say that? W Bay Area says, what about when Laura would say, do you know who I am? My father is Ron Owens, highly regarded SF talk show host. Well, I mean, she has said that. We've heard her say that, but I would love to know that she said that in public and people didn't laugh in her face right out loud. Like, I'm sorry. Yeah, even if they got another 100K at this point, they would still be in the same place within a few months, right? Like, it would maybe fund the float, but yeah, the stomach pains, right? I mean, I've been through really bad times. It is not fun. I cannot imagine being that age and funding things the way they have and still being so incredibly entitled. I'm just astounded. Yeah, okay, sorry. I'm gonna just start rambling at this point. But as somebody said something earlier about addressing the gambling, I saw it, but I don't know. I don't know. I'm a documents person, right? I can look at the bankruptcy case and break it down and tell you what I see. I can look at the mortgage chain history and break it down and tell you what I see. I cannot speak on unknowns, things that aren't documented, right? I have made assumptions, but I make calculated assumptions. So mine are more like, if I see a bunch of mortgages happening in succession, and then I start seeing people borrow from hard money lenders with really weird loan terms and stuff like that, I can make a calculated assumption that there's financial stress happening, right, in that household. So that's the kind of stuff I can do. I can't look at the information that we have in front of us and say, this is because of gambling. This is because of overspending. I can't even say it's because of funding whatever the fuck they've been funding all this time. I mean, clearly they're not using the money properly, but yeah. So Bruce says they need a power of attorney to take over and get their shit together. And Hava says that's what the chapter 13 would have done, but they wouldn't cooperate. Amen, sister. Like, it wasn't viable to begin with because they've over leveraged their house, but it would have helped them. I don't know. Yeah. White Rabbit Ann says they feel nothing because they think everyone else is wrong. They think they smell of roses and are hard done by. They don't understand why they are not treated as royalty. Yep. 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 It's wild. They need someone who doesn't need their cooperation to take over. Yeah. I don't know. Because whose problem is it really? The creditors? I don't care about the creditors. I really don't. I do care about I do care about fraud. I do care about the fraud that may have taken place in some things. I think that Laura's bankruptcy really opened the door for a lot of that to be brought to light, and I'm thankful for that because I see fraud in my job every day, and I don't see it prosecuted the way it should be. Like a lot of times when a mortgage, like when a foreclosure on a house happens, when a mortgage foreclosure happens, let's say the mortgage was obtained fraudulently by the owner, like under bad, like they don't care because they completed the foreclosure. Like they don't get into the nuts and bolts of how they got to this place, which is frustrating to me. But Bruce says, I mean, to make their lives better, someone else needs to run their finances. I absolutely agree. I just don't see it happening. No, that's another thing. They don't need 7 retire horses. Like, come on, for real. We do not need 7 retired horses. We shouldn't have any pets. Let's be realistic. Don't get rid of your pets, but really, you shouldn't have pets. You shouldn't have pets. If you cannot afford to survive on $21,000, I think it's $600 a month, you shouldn't have pets. But I don't know. Right. Exactly. They shouldn't, Salvadorian says, they shouldn't have 7 horses or a Laura. Right. because we're paying, I mean, according to Laura's sworn testimony, Ron and Jan are funding the whole thing. What's Laura's plan at the end? I don't know. Oh, God, that would give me anxiety because I have planned exactly for where I'm headed, and it has been difficult, and I am in a good place, but I am still nervous and scared about it. And I don't know how she can sleep at night not knowing what's going to happen to her in 20 years. Like, it's wild. Jamal says, it enrages me that Liz Jan is trying to pull this shit with her brother. Chances are we only know part of what he gave her over the years. And that's the other thing, right? I don't know. Even if we assume that he's like the worst guy, her arguments were invalid. That's all there is to it. Okay. Oh, one last thing. Sarah and Christian have high-paying jobs. I hope their finances don't suffer. If something happens drastically with the things that they have co-signed for, they'll recover. It doesn't take very long to recover. It's not great, but they'll recover. And I don't necessarily worry about that as much. As much as I don't worry about the lenders who might lose out, I don't worry about people who co-sign. And stuff happens because that's the risk you take when you co-sign. So, okay. I have rambled on long enough. Thank you guys for hanging in. I much appreciate that. We will absolutely, we're going to do a fun thing. I have to figure out how to put it all together. But we're going to do a fun thing with a rereading of the meeting of creditors with a little skit, basically make it kind of fun because everybody's got the video or the audio, but we're going to make it a little more fun and do some dramatics with it. And I also want to get some more videos out there about library stuff and other things. There's a lot to talk about. We haven't done it yet. So that's coming. But in the meantime, please, please, please get a library card. And in the meantime, we will see what else these people have in store for us. All right. Thanks, guys. Have a good night. Let's try it again. Oh, have a good night.